not a member of the commission.
Okay, great. Thank you. And I am really happy to see our guests. Thank you for taking the time out of your schedules to come. And thank you to everybody for attending our meeting today. Today's meeting is to discuss the two proposals that the Law Commission would like to bring before the 2025 legislative session. And other administrative and commission issues, we'll discuss those at our January meeting. So this is really just to approve those two proposals and discuss them and talk about them. And, you know, if you have any questions or concerns, we can sort of hash that out here. And I did want to mention that we had a program committee meeting this morning. Thank you to all of you who were able to attend that program committee meeting. We'll be talking about the two proposals. The committee did decide to move forward two proposals that we'll be talking about more in January. And those proposals are great. And so I'm really excited that we'll have some good discussion next meeting. And thank you all for all of you who were able to attend both that meeting and this meeting. Okay, before I go forward, we have a very special guest. I did want to introduce Tommy Grossman. Tommy is joining us here today in what is the top right of my square, Brady Bunch squares. Tommy's a third year at the University of Oregon Law School and is currently the Law Commission University of Oregon Portland Program Fellow. So that was one of the positions that we approved in our summer meeting. And so thank you, Tommy, for working with us and for attending the meeting today. Tommy went to UC Davis for undergrad and is interested in business litigation after law school. Sadly, when I had lunch with him, I was not able to persuade him that he really wanted to be a tax attorney. So still working on that. There's still time. I know, weird, right? So anyhow, so thank you, Tommy, for joining us. We appreciate it. Okay, great. So moving on to business. Amy, do we want to do introductions of folks, particular interested parties who are here?
Yeah, we can do that.
Okay.
Do you want to call names out rather than that might be best, or I could do
Sure.
that?
Yeah, and I don't want to make the meeting unnecessarily long, but I think it's lovely for people to know who's here. So I'm going to start on my immediate right, and if you could just say your name and where you work, and if you're visiting us today as an interested party, that would be great. Jamie.
Good morning. My name is Jamie Weddle-Jones. I'm the Senior Compliance and Operations Administrator at the Secretary of State Corporation Division, and I'm happy to be here.
Great. Thank you, Jamie. And Jamie was a huge help on the LLC Act too, so I'm particularly glad you're able to join us today. Krista Obold-Eshelman.
Hi, I'm Krista Obold-Eshelman. I'm a supervising appellate attorney at Youth Rights and Justice, and I am the co-chair of the Justice and Municipal Courts Appeals Work Group, so you'll be hearing more from me later.
Yep, great, thank you. Representative Wallen?
Sorry, I'm usually much quicker on the mute button. I'm Representative Kim Wallen. I represent Medford in the state legislature.
Great, thank you. Professor Bell.
Sorry, I was muted. I am Professor Bell. I teach at the University of Oregon. My specialty is criminal law.
We're very glad to have you. Thank you for coming. Judge James.
Hi, I'm Mary James, and sorry, I just pushed my printer button by accident. I'm a senior judge out of Marion County, and I'm in my 5th year of senior judging. And I was a litigator in Portland and Eugene and the Northwest for a long time before I was a judge for 20 years.
Thank you. Chief Judge Lageson.
I'm Erin Lageson, and I'm currently serving as the Chief Judge of the Oregon Court of Appeals.
Great, thank you. Cody Hosley.
Hey, I'm in Portland, and I am a civil litigator doing files and appeals.
And Cody was also a huge help on the LLC Act. Justice Duncan.
Hi, I'm Rebecca Duncan. I'm a justice on the Supreme Court and a member of the commission.
Thank you. Senator Pruzansky.
Good morning. State Senator from District 4, which includes large portions of Eugene and Springfield, also chair the Senate Judiciary Committee.
Great, thank you for joining us. Chris Colta.
Good morning. I'm a judiciary analyst with Alpro.
Great, thank you. Dean Dobbins.
Good morning, Jeff Dobbins. I'm interim dean and a professor at Willamette. Long time ago, I served in Amy's role. Law Commission was based here.
Great, thank you. Dexter Johnson.
Good morning, everyone. I'm Dexter Johnson from Legislative Council.
Great. Dean Perry.
Morning, everyone. John Perry, the interim dean at Lewis and Clark for 3 more weeks or so. And then I just get to go back to my honest job of being the just a regular old professor. So
Thank you, and good luck with the next 3 weeks. Jessica Menifee.
Good morning, everyone. Jessica Menifee, also from the Office of Legislative Counsel.
Great, thank you. Representative Krupp.
Jason Krupp, State Rep from House of 54 in Bed.
Great, thank you for joining us. Jenna Adams-Kallick.
Hi there, Jenna Adams-Kallick from University of Oregon Government Relations.
Great, thank you. And Kimberly, we won't make you introduce yourself again. Great, thank you all so much for coming today. Amy sent out the minutes from our October 11th meeting. Has everybody had a chance to review them? Does anybody have any questions or edits? All right, may I have a motion to adopt the minutes?
I so move.
Okay, second?
Second.
Okay, all in favor? Any opposed? Okay, great. Minutes pass. Fantastic. Great. So I am so excited that we get to talk about the Municipal and Justice Courts project. So I will turn it over to Krista and Justice Duncan to present and answer questions that we may have about it. And first, before you get started, Krista, I just want to say this was a Herculean effort, particularly in the last 6 months, to get this across the finish line. So both Krista and Justice Duncan deserve a tremendous amount of credit for navigating some pretty rocky shoals and discussions. So thank you very much for that. I know it was challenging at times.
Thank you. Well, it's definitely been my privilege to serve in this role with really a tremendous group of participants in this work group, and so much effort has been put in by so many people in making this come to fruition here. And I think we're excited about the product here. As you could see in the report, the primary goal was to reorganize, streamline, and clarify existing statutory provisions that govern appeals from justice and municipal courts. And during that process, we did need to make some policy decisions, mainly where there were gaps or lack of clarity in the current laws as we were reorganizing, and these areas are identified in the report. And since the finalization of the draft that you have, we have only heard one concern with the language that we'll need to address later. And I think that I'm very optimistic that, as with other decisions that's been made in this process, that this can be resolved with the work group participants and possibly, if we need to, an amendment during the legislative session. Apart from that, I think we're here to answer questions that you have. And I'm just open the floor.
Yeah, and I just want to mention that I do think that there's the programs committee talked about this project about an hour ago. And I think this is going to be similar to the probate modernization work group, where we have multiple work products coming out of a dedicated group of core people who are working on things. So this is the first tranche of that, but represents a tremendous amount of work and a lot of spirited discussions in an area that, frankly, I find absolutely mystifying. So thank you for doing this. And so I think we are expecting some minor tweaks in probably early January, February. And we're still searching for someone to help us pre-session file this one. So Representative Kropf and Senator Pruzansky, we may be reaching out to you with some questions about that. But is there any other discussion about the bill itself or the report? Questions for our chairs? Okay, great. In which case, I would like to move that LC 156 be presented. And before we do this, I think who was the person from LC who was helping us with this one?
Jessica Menifee.
Okay, I just wanted to also call out your excellent participation in this work group, Jessica. I think that if we had someone like you in all of our work groups, it would go so much more smoothly than could possibly hope. So thank you again for all of your hard work on that. Okay, great. So I do want to move that LC 156 be presented, that the Law Commission presented to the Oregon Legislature, the 2025 Legislative Assembly, with the recommendation of the Oregon Law Commission to move this forward. And I'm going to tag on to that because I think they really do march together, that the Oregon Law Commission adopt the Municipal and Justice Court's report to accompany LC 156, because I think it does a really good job of distilling down what the key issues are in a way that even I can start to have a grasp of what's going on. So do I have a second?
I second.
All in favor? Any opposed? Great. I believe we pass. Great. Thank you all so much. Really appreciate it. And thank you again to our chairs, our legislative council folks, and the work group for your hard work on this. Okay, so moving things along, the other proposal that we have to move forward is the Revised Uniform LLC Act, which we've talked about a lot in this forum. Thank you so much to Dexter for all your hard work and giving us a work product that we can be proud of, and that really reflects the hard work of the work group. I know it's a Herculean task because it's basically a 300-page bill. So keeping track of all the different threads, and it took me a while to go through and reread it and refamiliarize myself with it. But it's a very good work product, and I commend it to you for reading. So this basically is the bill that modernizes Oregon's LLC Act. It's not a particularly earth-shaking bill, but it will allow a lot of things that other states around us are able to do, as well as simplify things, I think, for Oregon businesses and business owners. And as we all know, LLCs are the most common form of entity that we form in Oregon today. So I think the impact of this bill will be pretty significant. Does anybody have any questions about the bill or any of the discussions that have been going on about it? There may be some minor tweaks to this one as well, just related to some discussions that are going on between the Uniform Laws Commission and OTLA. I know, Cody, I don't know if you wanted to talk a little bit about that, but I think the bill as it stands is very good.
My understanding at this point is that all the interested stakeholders have signed off on the bill, with the exception of 2 sentences in a single section. And right now there's a question as to whether those 2 sentences should remain in the bill or instead just be moved into the commentary. And it's a wrinkle I'm hoping, expecting we'll be able to iron out.
Yeah. So I think that it's 99.99% complete when you think about the substance of the bill. So I feel comfortable putting it before this group and moving it forward with the thought that maybe there is that minor change, which I don't see as particularly material, but other people have opinions. So if there are changes that are made, we will certainly advise you, but I don't think that we need the approval to move forward with minor amendments like that from this group. So any other discussion or questions, concerns? Yes, Chief Judge.
I'd just be interested in knowing specifically what the point of contention is.
Oh, yes, please, Cody.
Sure. So section 12 of the bill contains us 3 sentences. The first sentence is a sentence that you also would find in the Uniform Commercial Code, saying that the act does not displace general principles of law, such as common law of agency, things like that. And then there are 2 sentences following that, which go on to say, and these were added at the behest of Gary Byrne of the Stolburn firm, and who's associated with the Oregon Trial Lawyers Association. And these 2 sentences go on to say that, notwithstanding anything in the bill, limited liability company has certain liabilities based on statutes and common law, and the members and managers. And the Uniform Law Commission didn't like those last 2 sentences, and so suggested moving them to a comment. Fully my understanding is the Uniform Law Commission said they won't give our bill the seal of approval of being a uniform law if it has those 2 sentences in the bill, but they're totally fine if we move them to commentary. And so I have been in communication with Gary Byrne about what he thinks about that, and make sure the other stakeholders are fine with that change as well. Personally, I don't see a problem with leaving just the first sentence in there. I'm fine with the Uniform Law Commission's proposal in this regard. I didn't think we needed those 2 sentences anyway. I don't think they are substantively meaningful, particularly. But
Yeah, and I'll add that we discussed this in the work group too, and whether something additional was needed, and we didn't feel strongly that anything additional was needed, but Gary Byrne and Art Price with OLA, wanted to make it extra clear that common law principles still apply, which I don't think there's anything in the bill that says common law principles don't apply. So those discussions are ongoing. And I don't think that either way, it doesn't change the substance of the bill from my perspective. And I'm not particularly sure. I don't really understand why the Uniform Law Commission is being intransigent on this issue. So that's why I think that the discussion needs to continue with both parties to see sort of where we're going. Yes, Dean Perry.
I guess 2 questions. One is, how much does it matter to us if the Uniform Law Commission likes or doesn't like the work product we produce using the Uniform Act? And then the second one is, and I hesitate to ask this with judges on the line because it's a legal question, but I mean, if something goes into the commentary, what is the status of that? Does that count as legislative history if the bill is adopted, and then it would be subject to our
Excellent question. I mean, I think there are states I don't know that Washington is considered to be strictly conforming with the ULC either, but everybody knows that it is conforming with the ULC. So I think they also got to a point where they were like, no, this is what our work group has come up with. But and then I think, Cody, you've had specific discussions about the legislative history question.
yeah, I mean, I'm happy to defer to the judges who are here. My understanding is that there are several cases where the Oregon appellate courts have said that the Oregon Law Commission reports that we put out and the legislative history that we put in with the bill are powerful legislative history, particularly if the legislature passes the bill without much commentary of their own. So I think that, to the degree that there's any ambiguity in the statute, which I didn't think that there's ambiguity in the beginning, but to the degree that there is, it may well be something that judges are looking at to help resolve that ambiguity, and this would resolve it in the way that everyone had agreed to in the first place. As to the question whether it's important that we be recognized as having adopted the Uniform Act, I guess I don't know. I guess I had assumed that the goal of this body was to have it be labeled part of the Uniform Act, but I don't personally care. And we do have a bill that was signed off by all the Oregon people. So it sounds to me like a bill that could get passed. as is without pulling these two sentences into the commentary. So if we decide, well, we don't care that much, we care more about getting our bill passed as is, where it's been signed off by all the Oregon people, than we care about having to be labeled uniform by the uniform people, then I would say, let's just move forward with what we got. But if we really want to have that seal of uniformity, then we've got a little bit more work to do.
Yeah, I mean, I think it would be a helpful addition. In the past, when we talked about this in 23, they submitted a, yes, we like this testimony to the Judiciary Committee. So that would be nice to have. I would like that, but I want this bill to pass because I think that it provides really important tools for Oregon businesses. And I think this is again, I don't quite understand why this is such a issue for them. So if that's their line in the sand, that's their line in the sand.
Can I ask maybe a further question? I mean, it seems like it could be an issue to them because it seems pretty substantive, the extent to which a statute might displace the common law. I mean, is that the concern, is that they do intend the Uniform Act to displace the common law in some places, and this would sort of undo that clarity?
I wasn't on the call with the ULC people. Amy was, and maybe Lane was, or maybe it was just emails. I don't know. Amy, are you able to, or maybe, I don't know, Valerie, maybe you were on that call too.
I was on the call, and Lane was as well. And I think that to be honest, I'm not comfortable.
Yeah, so
I might need to get back to you on this.
So what I would say, Chief Judge Lageson, is that it was never the intention of the work group to displace the common law in the state of Oregon. So if that is the intention of the Uniform Law Commission, then that is an intention that is inconsistent with what the work group is doing and wants to do. So, we're not going to go back because a lot of what we were trying to do with this process was acknowledge where the common law is in Oregon, and to make it, I mean, particularly when we look at things like charging orders, we've had charging order cases in Oregon on how you implement and collect on a charging order. And the idea is to make it more transparent and clear and put into the statutes, here's the path to do that. And in a way that is consistent with the current common law. So I'm not comfortable doing thing that is inconsistent with the common law. I don't think that there's magic language that if you put it in or put it out or take it out would make this whole bill say we're going to overturn, decades of Oregon common law since, we had our LLC Act come into effect. So, but that's why I think that this discussion is largely academic, and I don't understand why they've decided to draw this line in the sand. My thought is that we probably will end up with the bill as it is now, but we'll just have to see where discussions with OATLAW and ULC go from here. Does that answer your question? Okay. Dean Dobbins.
So I'm just trying to figure out, right? It seems to me that it sounds like, as I understand it from Cody's explanation, the first sentence is fine.
Yeah.
Unless displaced by particular provisions of this act, the principles of law and equity supplement this act. It was simply clarification. I mean, was there some other language that Ola and others were interested in that would have modified that first sentence that would have satisfied them?
That's the two sentences that are in there now, is
Right.
the language that Gary Byrne from OATLAW wanted. And I did think when he suggested it, and I still think that it is just a clarification of that first sentence, or a reiteration of the principle behind that first sentence.
Yeah, it's in part, I mean, I didn't, Gary expressed a concern, and just one person, and he's just an attorney. He's not like the official voice of the Trial Lawyers Association, but he's a powerful voice within that organization. And he's been the person who's taken the big look at the overall bill for that organization. And in my view, I didn't understand his concern. And I didn't think there was anything to be concerned about. I don't think we've had a big problem when it comes to commercial law generally. That first sentence of this subsection 12 is in the Uniform Commercial Code, and it's been there for decades without any problem, as far as I can tell. So I didn't think that it's a problem to have that be in this bill. But he was concerned in large part for not knowing what arguments people might come up with or what judges might rule that got displaced by something in the statute. And so wanted to be clear that essentially nothing in the act was going to displace whatever other statutes or the common law say with regard to liability of companies and their members and managers. So I didn't think there was any key displacement going on in the first place. I didn't think there was a problem to be worried about. I thought this was a solution in search of a problem, but it was also a solution that didn't seem to me to have create problems of its own, at least not ones that I thought were a big risk, or that would be untoward. And so and the group agreed, and we've all moved forward with having these two sentences in there. But I understand that the ULC, the Uniform Law Commission, didn't like these two sentences. And so, I mean, if like I said before, if we want to just move forward and get this bill passed, I think we can do that as written. And maybe the pushback we do is, rather than pushing back against Gary and the trial lawyers to move these two sentences to the commentary, maybe instead the pushback is to the Uniform Law Commission and say, give us the seal anyway, or we don't care if you give us the seal or not. We have a bill that our interest groups have agreed to, and we're going to pass it.
Dean Perry, I think you wanted to say something.
I'm just visibly reacting, I guess, because it's just interesting. I was thinking about my old days in big law, about how I would seize on any change in language, and the word supplement seems weak to me. I'm sure that our courts will handle this appropriately, but I would love to know more about if these sentences really don't do much, then the basis for the Uniform Law Commission's objection is, I'm just mystified.
Same.
Yeah. But I'd prefer to keep it as the group came up with it.
I mean, I guess I would say that, obviously at the end of the day, you want something that's going to get the support and be able to be enacted. And so obviously when push comes to shove, you stick with what you need to. I just wonder whether sort of it's the scope of the additional language. Like, I have no idea. For instance, I could imagine saying something like, and I agree with you, John, that the principles of law and equity supplement these sections seems a little bit mushy, right? I could see something that said, unless explicitly displaced by particular provisions of the new act, common law supplements or something like that, right? I mean, I just wonder whether that's a small change in the first sentence that the ULC would be okay with, that you don't necessarily need everything else in the rest of it. But again, I know the difficulty here, right? Of like all of a sudden having 15 new people show up and start wordsmithing a little something that you guys thought you had resolved. So I also want to be understanding of that. So
we have very smart people in the room, so I value everyone's perspective. Representative Wallen.
Oh, I just was going to say, while that's true, what you just said, any of the 90 legislators could drop an amendment that did that exact thing, and there'd be no way to stop it if that group of people thought it was a good idea. So I don't have as much heartburn about maybe this group coming on and wordsmithing it now, because who knows what happens to it when it gets to the legislature.
Yeah, very good point.
can mention that the official commentary to the uniform law, it says that common law rules of contract and agency are among the most important supplemental principles of law. And then it says with regard to transactions under Article 10, which is like mergers and things, noteworthy principles include the rights of creditors following leveraged buyouts, spinoffs, asset purchases, and other similar transactions. Creditors' rights under other laws. And that's the end of the commentary to the official act. And then, here we would move that down to these two sentences down to say, sort of further elucidation of what is not being displaced by this act.
Can I make one more quick
Of
point?
course,
Sorry.
of course.
Because I'm thinking about this commentary. I mean, having some experience looking at the choice of law statutes, which have amazing commentary. It was before my time on the OLC, but wow. And then the Supreme Court issued a really important opinion portfolio case, and they referred to the commentary that came out of this group and gave it some authoritative weight. But I have to say I looked at the lower court briefing on all of that stuff, and it just wasn't anywhere in those materials. And I worry if we move something to the commentary, a lot of attorneys and a lot of judges who are busy people are not going to get to it and use it. But if something gets appealed up to the Court of Appeals, gets appealed up to the Oregon Supreme Court, yeah, they'll find that stuff. But I worry in the day-to-day practice, if it goes into the commentary, it's relevant, it's valid. If people find it and use it, they will, but I don't know. It also is partly buried. So, if this is an important point, it should be in the statute. If it's an irrelevant point, we can throw it in the commentary, but I think it's not interchangeable to me.
Yeah, that's valid.
I can offer a judicial perspective on that. We do read commentary, particularly in work product like that by the Oregon Law Commission, where the commentary is really well written, relatively short, easy to find. The consequence of moving it to the commentary is, in the section, it's going to be state a binding principle of law. So if a case comes up where a provision of this act is at odds with the common law, it's going to be a rule of decision. It's distinct from if it's in the commentary. It's going to be informative, but it won't supply the rule of decision.
If I am taking the temperature of the room, it seems like the temperature of the room would be to keep our bill as it is and go back to the uniform people and tell them, this is our bill we're moving forward with. Will you give us your seal of approval anyway? Try to convince them to do so. But if they won't be budged, then move forward with this bill anyway. Is that sort of the general preference of this group?
That would be my preference. Oh, Justice Duncan.
Can I ask a question? Is the uniform laws group concerned about a possibility that the first sentence means something different from the second and third sentences, and that the first sentence is, well, it's the act that takes priority and law and equity supplement the act, and that the second two sentences might invert that, or at least say that they are coextensive. And so if the group reached an understanding about how this act works with the common law, it would be great if that was clear either in the bill or in the commentary. I think is that the issue? Like, how do these, if you have a conflict between what's in the act and what's in the common law, how is that conflict resolved? And if the group has an understanding of that, maybe there's a way to clarify that, because I can see how those the first sentence might be viewed as possibly inconsistent with the second two.
If I'm understanding you correct, if the little notwithstanding clause in each of those second two sentences said notwithstanding anything else in the bill except the first sentence of section 12, would that resolve the concern we just raised?
If the idea of the group is expressed in that first sentence, and that the idea is that the act is going to take precedent over any contrary pre-existing common law or principles of equity. If that's the idea, perhaps we can just make sure that that is clear. I'm not sure it's entirely clear if we have all three of these sentences in 12.
It just puts some possible language that would change the first sentence and then just delete the rest, right? So if the concern is that maybe there's too much risk, or the concern on Ola's part is that maybe there's too much risk, that there's something floating around in the rest of the statute that might be possibly viewed as all of a sudden some displacement that's soft, then maybe you say it has to be an explicit displacement. There has to be, right? You're sort of raising the bar in terms of what counts as an overload. And then if you need to, you just make explicit reference to, rules of liability provided by any statute or common law for loss or injury, et cetera, et cetera. Leave it at that. I don't know. That's the sort of thing that I might try and take a run at both sides just to see if they could live with that and you leave out the rest. But again, I at the end of the day, I agree that if the language that's there is language that we need in order to get it passed, then you want to do that.
I think that's a great suggestion, Dean Dobbins. And so what I would suggest is that this group move the draft forward so that we can get it pre-session filed, with the understanding that we're going to have some additional discussion about section 12. And thank you for suggesting a possible solution to that. And Justice Duncan, I think your point about clarifying the relationship is important. I will say that it was the intent of the work group, and I'm saying this on the recording, so hello recording. It was the intent of the work group to, merely reflect what the common law is in Oregon currently, and not really to supplant judicial determinations with respect to LLCs that have provided really the backbone, because it has been so long since we looked at this act that a lot of the rules with respect to LLCs have come about through judicial determinations. Good. So I guess I'm going to move that this group move is there more discussion on this? Anyone else want to talk? Yes, Justice Duncan.
Just a quick, I think if explicitly might be a pretty high bar, because I think a lot of these things, it'll be like, well, if the act has a provision that clearly relates to whatever topic, and there was common law that was contrary to how the act would do it, it might not be an explicit displacement. It's just like there is this replacement, but it's not called out explicitly as intending to overrule such and such a case. So that might be a high bar. That's all.
Yeah, so perhaps just displaced, unless displaced by particular provisions.
Well, or clearly displaced, or something that's softer. I agree, Justice.
Yeah. And Dean Dobbins and Dean Perry, you can expect a phone call or an email from us in the next couple of weeks to be part of these discussions.
I hear that John's going to have a lot of extra time in a couple of weeks. So.
Yeah, I'm just teaching con law. There's nothing much to do with that. So.
Oh, we should talk. There's interesting things happening in con law world. So anyhow, what I would suggest, and I will move this formally. So I formally move that this commission adopt the LC 166. Is it 166? No.
266.
266, sorry. LC 266, the revised Uniform LLC Act, and move it forward together with its report, with the understanding that there may be some changes that we discuss in January to this provision 12. We will keep this group informed about how those discussions go, but I think Representative Wallen's point that, once it hits the legislature, anything could happen, it should also guide us. I mean, this is one of the things that we had to inform a lot of the lawyers on the work group, was that, we may think that this is the best language, but other people are going to have a hand in this as well. So, okay, so I'm going to move that we move this forward and present this to the 2025 session as a commission bill together with its report, which is written in plain English and much shorter than 300 pages. Do I have a second? Thank you, Judge James. All in favor? Okay, any opposed? Great. Thank you all so much for your time today. I really appreciate it, and I appreciate the good discussion too. You know, these are interesting bills that will be moving forward and reflect, you know, decades worth of a decade worth of man hours to get this done. So between the two of them, because I think we both were started right before the pandemic, and both work groups continued working on them through really challenging times. So I'll be very excited to see this. And thank you again to Legislative Council for attending this meeting and for all of your hard work on our behalf. I really value that partnership. Thank you, Justice Duncan and Krista. I really appreciate all your hard work on the municipal courts. And thank you, Cody. Really appreciate your work to help me understand litigation aspects and all your hard work on the LLC Act. So thank you all so much for your time today. I'm going to give you an hour and 15 minutes back. And we will be in touch. Dean Dobbins and Dean Perry. Thank you for your time today.